Hello, it's Mark Cunningham at Grace Property Management. So the Colorado Legislature has just closed out their 2021 session, and one of the bills that they passed in the session was HB21-1121. Long name, but it's called Concerning Protections for Residential Tenants Related to Actions by Landlords. And really this bill has two important components that impact every landlord in the state of Colorado and certainly every tenant in the state of Colorado. Now, number one relates to rent increases. Now, the old way of doing things, as it relates to landlords informing their tenants of a rent increase, was defined in the lease itself. There weren't a whole lot of laws regulating how and when landlords could give rent increases. So, for example, we may say, well, gosh, Mr. Tenant, your lease is up for renewal. You were on a 12-month lease. It's up for renewal, and so your rent is going up to X number of dollars. Or it's going to go month to month. And if it's on a month to month, maybe it went up and 6 months later it went up again. That's just the nature of Colorado. That's the way it used to happen. Well, the legislature didn't like that. So the new rule is landlords may only increase rent on their tenants one time in every 12-month period. One time in every 12-month period. What that means is, even if it's a month-to-month lease, you can't increase it more than one time on a tenant in a 12-month period. That's a change. Now, that's not some crazy law. I mean, typically, from the industry standpoint, tenants typically don't get rent increases more than once a year. So this shouldn't rock our industry too much. But if you're a tenant, make sure your landlord is not increasing your rent or has not increased your rent more than once in the last 12 months, or they would be in violation of this rule. And landlords, make sure you're not increasing your rent to your tenants more than one time in any 12-month period. And it doesn't matter what the lease says. It doesn't matter if it's a month-to-month lease or not. None of that matters. Now, there's some specific information in this law as well regarding how this notice is to be given to a tenant. We're not going to get into this here, but we will post a link to the full bill. You can read the full bill in its entirety. It's only actually 5 pages, so it's not a terribly long bill to read. We'll post a link to that right here in this post as well. So that's one important aspect of this new law. Now, the second important aspect of this new law relates to the legal side. When a tenant doesn't pay and the landlord goes to court to get possession of the property and all that's done, and what happens is it relates to what's called the writ of restitution. So here's the way that works. Let's pretend you are a landlord. You have a tenant in your property, and the tenant has not paid rent, and they didn't pay rent again, and they didn't pay rent again. So you finally go to court to argue that you want possession back of your property. And you say, hey, judge, the tenant hasn't paid the property in 6 months. I want my property back. And the tenant says what they want to say, and the judge says, you know what? I rule in favor of the landlord. Landlord, property goes back to you. They slam down their gavel, and I'm sorry, Mr. Tenant, you've got to get out. You're evicted. You are hereby evicted. You got to get out. Possession of the property goes back to the landlord. And the landlord says, yay. And the tenant says, oh, bummer, I got to move. The way the old law was written is the tenant had a minimum time frame of 48 hours before basically the sheriff could come out. Okay, so judge rules in favor. Possession is yours. Legally, your tenant has 48 hours, minimum of 48 hours, before the sheriff can come out and say, hey, Mr. Tenant, you got to move. You got to get your stuff out. Now, the reality of it is, between the time the judgment is issued and between the time the sheriff actually would get to a property is weeks. So the tenant has a long time, practically speaking, to get their stuff moved out of a property. They really do. They have a long time to get that done because sheriffs are behind in getting this done. But technically, the sheriff has to give them at least 48 hours. That was the old rule. Well, under the new rule, the sheriff needs to give them already 48 hours. They need to give them a full 10 days. So now, if you as a landlord go to court against your tenant resident because they haven't paid rent and you win possession of the property, you have to give your tenant a minimum of 10 additional days to vacate the property before the writ of restitution can be authorized by the sheriff. This, again, probably isn't going to be real earth-shattering to the property management industry. Why? Because sheriffs are typically giving tenants at least 10 days, more like 3 weeks, before they're even able to get something scheduled. So tenants really have plenty of time to get their stuff out of a property. versus having a sheriff come out and physically remove. Nobody likes that. Nobody wants to have their stuff physically removed from a property by other individuals. So it's a pretty rare thing to happen, but it does from time to time, and if it does, there's some new rules governing that. So none of these things are that dramatically going to impact the industry, in our opinion. Now keep in mind, these things are immediate. So when the law was passed, there's a certain thing in the Colorado state law where it's called a safety clause, And what the legislature can say is they say, hey, the General Assembly, this is their verbiage, the General Assembly hereby finds and determines and declares that this act is necessary for the immediate preservation of the public peace, health, or safety. So in other words, like, this is an emergency. We can't wait to start this next year. This is immediate, has to go into effect right now. And this does go into effect right now. So as of now, we're recording this here in July of 2021, landlords, you cannot give your tenants more than one rent increase in any 12-month period. And courts are already taking care of the writ of restitution aspect of things. Now, next month we'll be addressing the longer, more complicated law that also passed governing tenant landlord law here in Colorado. But if you have questions on this as a tenant, as a landlord, feel free to reach out. We're here to be a resource. Jump on our website, rentgrace.com, where you can find information. If you're one of our current landlord clients, don't worry. We have all of this handled for you. If you're looking for a property management company, we'd be honored to talk to you about that. We've been in operation for 40 plus years and have seen just about everything here in the industry. But listen, I wish you a lot of success to our tenants, to our landlords. Thank you.